The professional liability insurance that design professionals bring to a project provides a huge benefit to their property owner and real estate developer clients, but this benefit is misunderstood, and I like to dispel some of those myths. Sure, professional liability insurance will provide a defense to design professionals in the event of claims. But what their owner and developer clients need to understand is that this professional liability insurance is also there to write settlement checks to them in the event that there is actual design malpractice by the architect or the engineer. And so there's a handful of things that owners and developers should think about when they consider professional liability insurance. One is that professional liability insurance is really the only meaningful protection that project owners and real estate developers are gonna have against design malpractice. You know, it's not something that is necessarily intuitive, but if you stop and think about it, most of the cash on a construction project is gonna run through the contractor. It's labor and it's steel and it's concrete. And the design firms generally will have a comparatively small fee. The money that they collect in their fees goes to pay their subconsultants, and it is often quickly paid out in rent and salary. And so there is almost never a circumstance where a design firm is going to have a huge stockpile of cash on hand. So if an owner or developer has a legitimate claim against an architect or engineer for design malpractice, unless they're able to go to a professional liability insurer that provides coverage and will take care of that problem, will cut a check to the owner or developer in order to settle the liability of the architect or engineer insured, there's potentially very little other source of recovery that the owner or developer is going to be able to stick their hand into in order to salve their financial wounds. Architects and engineers do typically carry other kinds of insurance, but that insurance really does not protect them from design malpractice. There's commercial general liability insurance, otherwise known as CGL insurance, and I think that all businesses should have it, whether you drive an Uber or you have an ice cream truck, or you're a dry cleaners, you carry CGL insurance. But that insurance almost universally has an exclusion for design malpractice. So while architects and engineers will bring a CGL policy to the table, it's typically not going to provide any meaningful benefit to their owner or developer clients in the event of design malpractice. That professional liability insurance is really what counts. And to give you an idea of how significant of a situation it is where you have an uninsured claim against a design firm, a firm that, like most design firms, does not have the cash on hand to write checks to settle any liabilities that they may incur in the event of design malpractice. Back when I worked at the big law firm, there were circumstances where I brought my bankruptcy attorney partners with me to meetings with my architect and engineer clients where we had unpleasant discussions about how this claim is real, it's scary, there might not be insurance or there might not be enough insurance. And so these design firms were not talking about digging deep to write checks, they were talking about going out of business. So this is not a hypothetical concern, this is a real concern. Owners and developers also need to understand that professional liability insurance can be destroyed by contract terms. I won't get into the specifics in this video, but if an architect or engineer extends a warranty or a guarantee or provides an agreement to defend a party by contract or agrees that the winner in a lawsuit will be paid the attorney's fees by the other party, which is a prevailing party clause, coverage under a professional liability policy can be destroyed. And this is really not in the interest of either the design firm or their property owner or developer clients. And this is not just because the professional liability coverage is the only asset that the design firms are bringing to the table to cover their design malpractice. It's also because of what happens in the event of claims. When an owner or developer asserts a claim against a design firm that is couched in terms of a warranty or a guarantee, what does the design firm's professional liability carrier do? Well, it can vary in different circumstances, but in many cases, what will happen is the insurance company will issue a reservation of rights letter and say, we don't cover you for this. So while we're not necessarily running away from this or denying coverage outright, at the end of the day, if you are found liable under a warranty or a guarantee, theory, or if you are found to have an obligation to provide a defense for another party, you're on your own. And practically speaking, a professional liability insurer that has coverage defenses is going to behave differently in a claim situation than one that does not. If you have a very clean claim against an architect or engineer that is couched in terms of negligence and breach of the standard of care and doesn't contain any of these other things that might be uninsurable, a professional liability insurer is going to be much more willing to listen to attorneys like me when I say, let's try to figure out a way to achieve early, cost-efficient dispute resolution. Let's talk about a mediation. Let's talk about trying to figure out how to get the claim settled without years of protracted litigation or arbitration, so that the design firm can get back to doing what they're best at doing, which is not defend claims, it's create great buildings that we all enjoy. So owners and developers should understand that if they want to have these checks written to them by professional liability carriers, if they want their claims to be resolved quickly through negotiation rather than through protracted litigation, it doesn't make a lot of sense to insist that there be uninsurable contract terms in the architect or engineer's contract.